Hello and Happy New Year. Welcome to our January 2025 Seat at the Sitting. I'm Nate Kazmarek, Vice President and Director of the Practice Groups. Today, we are excited to dive into the upcoming oral arguments before the Supreme Court starting next week. Our aim is to host an informative discussion for 90 minutes or less, and we have gathered a talented and rather large expert panel to help us out. As our audience knows by now, the Federalist Society doesn't take positions, and all views expressed during this program belong to our speakers. We are fortunate to have Brett Nolan of the Institute for Free Speech to guide our panel. Brett, how are you this afternoon?
I'm doing well. How are you, Nate?
Great. All the better for your presence. I'm glad you could join us today and help us out. Brett is a senior attorney at the Institute for Free Speech, a public interest law firm that is dedicated to First Amendment rights. Before joining the Institute, Brett served as the Principal Deputy Solicitor General of Kentucky. Prior to that, he served as Deputy General Counsel to the former Governor of Kentucky. He clerked for Judge John Nalbandian for the U.S. Court of Appeals for the Sixth Circuit and Judge Karen Caldwell of the U.S. District Court for the Eastern District of Kentucky. His law degree is from the University of Chicago Law School. Brett's full bio and the bios for all of our presenters today are available for your review on our website, fedsoc.org. The panel today will cover the upcoming cases, and then we'll go to audience Q&A. So please think about the questions you'd like to submit to our experts in advance. We are streaming on several FedSoc platforms this afternoon, but if you have joined us via Zoom, your questions can be submitted with the Q&A function at the bottom of your screen. We may end up tight on time, but we'll answer as many audience questions as we can get to. And now, with the table set, Brett, the floor is yours.
Thanks, Nate, and thanks to everyone for joining us. This afternoon, we've got a great panel lined up to talk about the January sitting, which is actually starting a couple days earlier than originally planned because of some shadow docket activity over the last few weeks. I'm going to start by just very briefly introducing all of our panelists. As Nate said, you can read everyone's full bio at fedsoc.org. I'm going to go through them all at once and then move toward talking about each of the cases. So first up, we're going to hear from Professor Michael Domino, who is a professor of law at Widener University, Commonwealth Law School, where he teaches constitutional law, election law, federal courts, and a lot of other interesting subjects. We have Vikrant Reddy, who is a senior fellow at Stand Together Trust. He specializes in criminal justice reform issues. Shannon Grammel is counsel at Lahotsky Keller, where she litigates on a wide variety of matters involving constitutional law, administrative law, election law, complex commercial disputes, and more. We'll have Jennifer Dickey. Jennifer is the Deputy Chief Counsel at the U.S. Chamber Litigation Center, which is the litigation arm of the U.S. Chamber of Commerce. We'll hear from Brian Weir, a partner and litigator at Consovoy McCarthy, who specializes in constitutional and regulatory matters. And finally, our last speaker today will be Greg Porter, a partner at Bailey Glasser, where he leads the firm's ERISA and Trust Practice Group. So we're going to start with our first case, which the court is hearing tomorrow. And for that, I'm going to turn it over to Professor Domino to tell us about TikTok v. Garland and what exactly is going on with this late addition to the court's docket.
Thanks very much, Brett, and thanks, Nate, and the entire Federalist Society. It's a pleasure to be here. Thanks also to the rest of the panelists and to the audience for tuning in. It really is a delight and an honor to be here. The TikTok case concerns, as I think most people who would be tuning in to this session already know, the forced divestiture of TikTok that Congress passed last year and President Biden signed. It is formally called the Protecting Americans from Foreign Adversary-Controlled Applications Act. The act is set to take effect. The divestiture requirement goes into effect on January 19th. But that date was not specifically set in the statute, at least in so many words. Instead, the ban was supposed to go into effect 270 days from the enactment, and it just so happens that the 270th day is January 19th. So by a sort of coincidence, the act comes in and takes effect the day before the inauguration. The free speech claim in this case is in an important way very similar to the free speech claim that is presented in another case that I'll be talking about later on in the program, the Free Speech Coalition versus Paxton. And it involves one fundamental aspect of First Amendment doctrine. And that aspect is that content-based restrictions on speech trigger strict scrutiny. That is, if the government wants to restrict speech based on the content of the speech because of a fear of what is being communicated, that's constitutional only if there's a compelling reason for restricting the speech and if the restriction is narrowly tailored to serve that compelling interest. If, on the other hand, a restriction on speech is only incidental, that is, if the government passes a restriction on content that also has an effect of restricting speech, then that restriction is evaluated not under strict scrutiny, but under intermediate scrutiny. And those of you tuning in who are lawyers will remember the classic case of United States versus O'Brien, which involved a ban on people burning draft cards. O'Brien wanted to burn his draft card as part of a protest, but the court said, we're not going to apply strict scrutiny there. We're going to apply intermediate scrutiny. So with that in mind, TikTok specifically, the forced divestiture of TikTok is based on a concern about Chinese influence over the application. And there are two different concerns that might very differently affect the constitutionality of this statute. The first concern is that because of the Chinese ownership interest or control over TikTok, they have access, the Chinese government, and therefore the Chinese Communist Party, has access to data about the 170 million Americans who use the TikTok app. Literally half the United States is a user in any given month of TikTok. And because the Chinese government has control over the parent company of the American affiliate of TikTok, the Chinese government can demand access to any of the data that is collected by TikTok, which the government asserts presents a significant national security risk. The second concern is that it at least is possible. There's no specific allegation that this has happened with respect to TikTok in the legal proceedings, although there have been news stories about this. But in any event, it is at least possible that the Chinese government is influencing the algorithm that TikTok uses, and so is feeding TikTok users material that is biased in favor of whatever positions the Chinese government wants to take. And because China is an adversary of the United States, it is suggested that China is using the TikTok app to foment various kinds of problems in the United States to increase, for example, support for Palestinians in the Israel-Hamas conflict, or to suppress material that is critical of China with regard to, for example, the Tiananmen Square massacre. All of these are various allegations about things that China might be doing, could be doing, to influence Americans' views of foreign affairs and of whatever other kinds of public affairs it wants to influence. Now, the United States government, in defending the ban, suggests that this really isn't a First Amendment case at all. That is, it doesn't implicate anybody's First Amendment rights, because the Chinese Communist Party, any kind of foreign entity, doesn't have any First Amendment interests whatsoever. And although TikTok Inc., which controls the app, is a California corporation and American corporations have free speech rights, the government asserts that the American corporation is merely a kind of puppet that's being controlled by the Chinese masters. So the speech that is involved in the creation and manipulation of the algorithm would be China's speech, or ByteDance's speech, this parent company of TikTok, and not any American speech, any speech protected by the United States First Amendment. TikTok, of course, disagrees. A bunch of amici disagree and say that this law either directly limits the American subsidiaries' speech, or or the speech of American TikTok users, who would be limited in their ability to use the app, to post on the app, to get information both from domestic and foreign sources if TikTok were to go away. And because ByteDance is unwilling, or at least professes an unwillingness to divest the app, the result of this forced divestiture will be shutting down TikTok. The control, as I said, the concern about the data being given to China is probably, although there's some dispute on this, but probably content neutral. And so if that were the only justification for the act, it might well be evaluated under intermediate scrutiny. The potential problem with that is that there is this second justification, the concern that the algorithm is manipulated in a way to give Americans the wrong views about things. That has been characterized as content-based, indeed viewpoint-based discrimination. And so to the extent that the government is seeking to ban or force the divestiture of TikTok for those kinds of reasons, because we don't like the messages that Americans are being sent, or we don't like the attitudes that Americans are getting through this information source, that may well be a content or viewpoint-based reason for restricting the speech, which would trigger a higher level of scrutiny. If strict scrutiny applies, there is certainly a compelling interest. Protecting Americans from a potentially harmful foreign adversary is certainly compelling, but there is a strong argument that the government's forced divestiture is not narrowly tailored to serve that interest. If, on the other hand, intermediate scrutiny applies, then there's a much greater argument that that the law is adequately tailored to serve that indisputably compelling interest. I'm gonna stop there because I don't want to intrude on anybody else's time, but I'll mention the really especially interesting aspect of the litigation here before the Supreme Court is that incoming President Trump has filed a brief arguing that the court should delay the implementation of this forced divestiture to give him a chance to renegotiate it, so as to find some kind of way of keeping TikTok operating while also attending to the national security risks posed by the app. So with that, Brett, I will stop and turn it over back to you and the rest of the panelists. But thank you all very much.
Thank you, Professor Domino. I'll just remind everyone to, if you have any questions for the panelists, to submit some questions into the Q&A feature of Zoom, and then I'll hand it over to Vikrant Reddy, who is going to tell us about Hewitt v. United States.
Thanks so much, Brett. Can I ask a quick clarifying question? I was going to talk about both Hewitt and Barnes versus Felix. Should I do them both, or just one now and the second one at another time?
We're going to loop back to you near the end, so that we break it up a little bit. Thank you.
Oh, okay. No, that sounds great. All right. Well, then let's talk about Hewitt. So Hewitt is a case that is about the First Step Act. And at first I thought, well, I don't really have to describe what the First Step Act is. Everybody would probably know. But then it occurred to me that there may be 23-year-old law students on this call right now who 7 years ago when the First Step Act was passed, were thinking about the homecoming dance or something like that. So perhaps it is worth digging ever so briefly into what exactly the First Step Act was. This was a federal criminal justice reform law. It was pushed and passed by Congress in 2018 and then signed into law by Donald Trump. The concerns at the time were that the criminal justice system had become excessively punitive in a whole host of ways, and Congress was trying to find a way to fix this problem. They did a whole bunch of different things. There are provisions in the First Step Act that allow for more programming inside prisons. There are provisions inside the First Step Act that allow for more earned time off your sentence if you're an inmate who's keeping his nose clean behind bars. There's a lot of different things in the law, but for our purposes, one thing that the law did was it took on a big controversy over Section 924C. What's 924C? This is a mandatory minimum that's become very kind of notorious in the defense bar. What happens with 924C is that suppose you commit a crime. It's a violent crime or a drug crime, and you get sentenced for whatever that underlying crime is. But if you've got a firearm present when the crime is committed, then all of a sudden there is a sentencing enhancement. You've got 5 years on top of whatever the underlying sentence was. On top of that, suppose there's another incident. Incident is a key word here. We'll get into that in a second. That tacks on another 25 years. The reason I say that incident is a key word is because the original idea behind 924C was that you were trying to get repeat offenders. But what you could do actually is take the same offense, charge it in multiple ways. There's a whole bunch of counts. And then when you keep getting convicted on each count, you can tack on 5 years and then 25 and immediately escalate the sentence to the point where you get, honestly, sentences that are in the hundreds and hundreds of years. And in fact, that is Hewitt's case. We'll get to that in a second. I want to tell a quick anecdote about how this kind of thing worked in practice and about why the First Step Act took it on. I know a guy named Weldon Angelos. This became a very famous case. Weldon was a record producer in Utah who sold about $350 worth of cannabis to an undercover police officer. He had a firearm strapped to his leg at the time. I think that probably happens a lot in Utah, whether you're selling cannabis or not. I'm from Texas, and the number of people who've got a firearm strapped to their leg at all times is quite high. But this is what happened to Weldon because he had the firearm strapped to his leg when selling, again, just $350 worth of cannabis. He was charged in multiple ways. The charges stacked up, and he ended up getting 55 years behind bars. Judge Paul Cassell, who sentenced him, is no longer a judge. He's now a professor, I think at the University of Utah. Is a brilliant judge, a brilliant professor, famously a bit skeptical about criminal justice reform efforts, nevertheless said that the sentence against Weldon was completely outrageous. 55 years for $350 worth of marijuana. A gun was not used, it was simply present. And Judge Cassell himself actually argued for some clemency for Weldon Angelos. After serving 13 years, he was released. He was pardoned by Donald Trump. There was a big campaign led by many celebrities to help Weldon. And I would say this is the key case that kind of put 924C into the public legal conversation when the First Step Act was being debated back in 2018. That was the turning point. So let's get back to the Hewitt case. The First Step Act modifies 924C so that instead of having this extra 25 years get tacked on, each additional count is only going to carry 5 years. Now, that's also, a pretty significant sentence, but it is a major reduction beyond what we'd had previously. It's also worth noting, and this becomes super duper relevant momentarily, that this was not made retroactive. So, Hewitt is a guy from Dallas, I'm from Dallas actually, who committed a series of armed robberies with some associates in 2008. These guys got together. They called themselves the Scarecrow Bandits. That's a detail that I find funny because it reminds me of the Wet Bandits in Home Alone. Don't know why you have to name yourself, but that's what they did. The Scarecrow Bandits went around the DFW Metroplex and they robbed a bunch of banks. Armed robbery is a serious crime. It deserves a serious sentence. And in fact, Hewitt got a serious sentence. In fact, I would argue that he got an absolutely absurd sentence. His sentence for the armed robbery was 355 years in prison. Professor Doug Berman is a criminal law professor at Ohio State, has a very colorful way to illustrate what is meant by 355 years. He says, listen, if John Adams and Thomas Jefferson were sentenced in 1776 by the British to 355 years for treason, they would still be serving the sentence today, and they would have about 100 years left on the sentence. That is an extraordinary and absolutely absurd figure, 355 years. How did it happen? Well, it happened through the 924C stacking, obviously. Hewitt and his associates were charged with, Hewitt in particular, was charged with 14 different counts. I don't remember all the counts off the top of my head, but you have things like conspiracy, you have bank robbery, you have attempted bank robbery. You add them all up, you apply 924C, and you get to 333 years. And then for reasons that are unclear to me, the judge tacks on an extra couple of decades, and you get yourself up to 355. This all happens, the crimes happen in 2008, sentencing happens in 2010. Then the First Step Act is passed in 2018. Now here's what happens in 2020. For technical reasons, some of the counts are actually dismissed against Mr. Hewitt. And so you're put in a position now where he has to be resentenced. And the question becomes, is he resentenced subject to 924C as it was before the First Step Act, or 924C after the First Step Act? This is the debate. Hewitt obviously thinks that he should be sentenced to the under the new 924C provision. And in fact, he's got a lot of support from multiple amicus briefs. One amicus brief actually came from 4 of the senators who are most prominently involved in the First Step Act, 2 Republicans, 2 Democrats, Mike Lee, Chuck Grassley, Dick Durbin, and Senator Booker, all filed a brief in his support. Also, interestingly, supporting him is President Biden's Justice Department. They were not willing to defend the 355-year sentence. They were not willing to defend an interpretation of the First Step Act that says that the pre-924C rules are what apply. So because he couldn't even get the government to step up and make that defense, the Supreme Court appointed an amicus to make the defense, to make that position supporting the alternative view of 924C. That, I think, is going to be a very, very difficult case to make. I think often in situations like this, the Supreme Court knows that someone's got to play devil's advocate. They appoint somebody to make the hopeless argument. Michael McGinley of Detchert was appointed to this kind of thankless role. I wish him the best. He seems like a great guy who's frequently involved in Federalist Society events. But unfortunately, I think somebody just has to take the L in this case, and he was appointed to be that guy. Someone's got to do it. The case is going to be argued next week, as a matter of fact. I think it's on the 13th. And I have a strong sense of the direction that it will go, but I've been wrong before. And that, in brief, is Hewitt versus the United States. I can't hear you, Brett. I think you're on mute.
Sorry about that. Thank you. We're going to go next to Shannon Grammel, who will tell us about Thompson v. United States.
Thanks very much, Brett. And thanks also to the Federalist Society for having me today. I want to start by apologizing for my voice. I seem to have caught whatever has been circulating around the country. So for your sake and mine, I'll try and keep this tight. The case I'm talking about is Thompson versus United States, which is a statutory interpretation case. It involves a federal law, 18 U.S.C. Section 1014, that prohibits making a false statement, that's the key phrase, for the purpose of influencing certain financial institutions and federal agencies. This case involves Patrick Daley Thompson. Any of you from the Chicago area would be familiar with probably the Daley family, who is big in Chicago politics. A couple of former mayors, and I take it that Thompson himself spent some time on Chicago City Council. But anywho, Thompson borrowed a total of about $220,000 from a small bank in Chicago. And that was over a series of 3 loans. He took out about half initially, and then later took out the other half in 2 loans. He only made one payment of about $400, and a few years later, the bank went under. There was some embezzlement going on at the bank, and then it went under. The FDIC hired a firm to collect what Thompson still owed to the bank. He disputed that he owed the $219,000, and what he told them was he had borrowed $110,000. Things went on. They eventually settled. He agreed to pay $219,000, the amount he borrowed, but minus interest. He was later, I think a couple years later, was charged with violating this federal law, section 1014, that makes it a crime to make a false statement to influence these certain agencies. The prosecutors focused on the statement that he had only borrowed $110,000. He did not mention the other money he had borrowed, and they said that that was a false statement. Thompson said it was not a false statement because he did borrow $110,000. He just also borrowed more money. So technically his statement was true. And under the terms of the law, he says it's not false. The Seventh Circuit rejected his argument and said that under binding circuit precedent, literal truth is not a defense to section 1014. It covers both false and misleading statements. So the Second Circuit was part of a pretty big circuit split, a 3-4 split. The Seventh Circuit's on the long side, along with the Fifth Circuit, the Eighth Circuit, and the 10th Circuit. And those circuits all say that both false and misleading statements can serve as the basis for a 1014 charge. The First, Fifth, and 11th Circuits require or say that only false statements, not just misleading, only false statements qualify. So that's the issue. The parties make a bunch of kind of the statutory interpretation arguments you would expect. Thomas, for his part, focuses on the word false in the statute. The statute does not say misleading. A lot of other words say both false and misleading. That's a sign that Congress would include misleading when it wants to. And it's also a sign that false does not include misleading, because then misleading would be superfluous. Thompson also says that the criminal statute should not be construed more broadly than its literal meaning. It is a criminal statute after all. And he invokes the rule of lenity. He also points to a prior case from the court, which held that writing a bad check did not violate section 214 because a check is not literally a statement. So he says in the same way, his statement is not literally false. He also relied on a case interpreting the federal perjury statute to not prohibit testimony that's technically true, but misleading. And he relied on, he noted that the government's non-literal interpretation of the statute would criminalize a lot of technically true but misleading statements that are commonplace in the sorts of loan negotiations that happen every day. So for instance, if somebody mentions that they have another offer and they disclose some of the terms of that offer, but not all of the terms of that offer, is that the sort of misleading statement that would trigger liability under the statute? So that's kind of in short Thompson's argument. The government, as you do in cases like this, also starts with the text and says that in ordinary usage, something is false if it doesn't convey the whole truth, in circumstances where the listener would believe it to convey the whole truth. So here, if you disclose you've borrowed $110,000, but not the other $110,000, that's false. Just like if a cop pulled you over and you said you'd had 1 beer, but you'd also had 3 glasses of wine, that would be false. That's the example the government gives. The government looks to the context of section 1014 to confirm this. It broadly says any false statement of any kind. And in the lending context that the statute operates in, accuracy is extraordinarily important. Government also finds a Supreme Court case on its side, K versus United States, where the court determined that similar language in a predecessor statute about false statements to another agency included both false and misleading statements. And then the government also looks to kind of the policy implications of Thompson's argument and says that, well, actually, no, they don't. What they look to is other statements made by Thompson. They make the argument that Thompson made statements that actually were literally false. He said he borrowed $110,000, the government says, which is literally false. And there was a second statement about what he used the money for that was in fact not true. So the government kind of argues that alternative basis there as well. But I believe this is also up next week, and we'll see what the government or what the court does with it.
Thank you, Shannon. Just a reminder, if you have any questions, to submit them through the Q&A feature, and we'll get to those at the end of our panelists talking about each of the cases. Now we're going to go back to Professor Domino, who has two cases he's going to tell us about. Waitzig v. Halliburton Energy Services and Free Speech Coalition v. Paxton. Professor Domino.
Thanks again, Brett. Before I begin on those, I should mention one thing about the TikTok case that I neglected to mention before. For those of you who want a more full discussion of that case, you're welcome to refer to the excellent debate that was held as part of the Federalist Society's National Lawyers Convention in November between Pat Philbin and Miguel Estrada, which I believe is available online. The Waitzig case will be argued next Tuesday, January 14th. It involves a question of civil procedure, specifically the interpretation of Rule of Civil Procedure 60B, which allows a court to relieve a party from, and this is the key phrase, a final judgment, order, or proceeding, unquote. The case arises out of an employment discrimination action, which was initially filed in court and then voluntarily dismissed under Rule 41 so that the parties could pursue arbitration. Rule 41 says it explicitly allows this kind of action and says that without a court order, the plaintiff may dismiss an action by filing a request for dismissal. And the rule specifically says that if that happens, that the notice of dismissal is without prejudice. Unless the notice or stipulation states otherwise, which it doesn't here, the dismissal is without prejudice. So case is dismissed voluntarily, goes to arbitration. The arbitration doesn't come out the way that the plaintiff wanted. Not only is it not resolved the way the plaintiff wanted, the plaintiff complains about various problems with the arbitration, inadequate notice, no recording of the proceeding. So the plaintiff is complaining that the arbitration was not handled appropriately. And so the plaintiff goes back to court and says, well, I want relief from the dismissal. And the district court says, well, yeah, there's problems with the arbitration, so I'm going to grant you that relief. But the Court of Appeals reversed and said, this is not kind of final judgment or proceeding that Rule 60 refers to. And so the district court had no jurisdiction to allow this relief from the voluntary dismissal. And there are two questions relating to the interpretation of this statute, or two key words that are at issue. The first one is final. Is the dismissal, this voluntary dismissal without prejudice, final within the meaning of the rule? If it's not, then the district court did not have the authority to relieve the plaintiff of it. Now, it is final in the sense that it resolves the case. It is case dispositive. The case is dismissed, whether voluntarily or not, whether without prejudice or with prejudice, it resolves the case. On the other hand, it doesn't resolve the issue because it's without prejudice. dismissal without prejudice allows the plaintiff to return to court, raising exactly the same issue in a new action. And so the defendant, Halliburton, says this is not final. The voluntary dismissal without prejudice is not final. And so there's no authority for the district court to relieve the plaintiff of it. The plaintiff argues that it is final because it resolves the case. If he were to exercise his authority to bring a new action, it would be a new action, and the old one would have been resolved. So as far as the first case goes, the dismissal is final, and he analogizes the argument to other kinds of final orders that are subject to appeal within the federal system. And he says that what final should mean in this context is not interlocutory. Interlocutory orders should not be subject to Rule 60, but everything else, the same kinds of orders that are final for purposes of appeal, should be final for purposes of this provision as well. The second portion of the statute that is in dispute it says, even if this is a final something, if this dismissal is a final something, is it a final judgment, order, or proceeding? Well, it's not a judgment or order because the court isn't involved in this. Remember, the dismissal under Rule 41 here was done without a court order. The court doesn't do anything. The plaintiff just says, I am voluntarily not pursuing this case anymore. And so it's not a judgment or order. Is it a proceeding? Plaintiff argues that it is, and that a proceeding basically refers to any kind of action in pursuing a claim, whereas the defendant says, no, a proceeding has to be something more resembling a hearing, a stage in the litigation, or something along those kinds of lines. So this is not one of those cases that's going to grab many headlines in newspapers compared with some of the others that are argued this session, but I think that's a sufficient summary of the issues that are involved in it. The next case that I'm going to talk about, which will be the one that's going to be argued next, this one is on Wednesday, January 15th, is Free Speech Coalition versus Paxton, the Attorney General of Texas. Case involves a First Amendment challenge to a Texas statute that limits access, restricts access to online pornography. The claim is that the materials that are posted on some of these websites are obscene as to children, as to minors. That is to say that minors have no constitutional right to access the sexually themed material that is the subject of this restriction. Adults, however, may well have a constitutional right to access this material. It is to say, the material that's posted on these websites is not obscene, or at least some of it is not obscene as to adults, but it is obscene as to children. Children, therefore, have no right to access it, but adults do. Well, the problem is that online sites then, the problem is that the statute requires the websites to verify or ascertain the ages of the people who are trying to access the material in order to ensure that children are unable to do so. So the statute imposes a requirement on these websites to basically take age verification methods to get people's IDs or whatever else. Now, as applied to minors, this is not a problem. Minors have no constitutional right to access the material anyway, so no constitutional problem in limiting minors' access to the material. The problem is that these age verification measures impose a burden on adults accessing the material when the adults do have a constitutional right to access the material, and the websites have a constitutional right to distribute the material to willing adults. And so the question is whether these age verification methods impose an unconstitutional restraint on adults' ability to access this material, even though the goal of the statute is to prevent minors from accessing the material. More specifically, the question that the Supreme Court's going to decide is what level of scrutiny applies to reviewing that question. So, as I said before in my discussion of the TikTok case, content-based restrictions on speech generally require the government to satisfy strict scrutiny, whereas content-neutral restrictions allow the government to satisfy a lesser standard of intermediate scrutiny. Well, in this case, the question is, do we apply strict scrutiny to evaluate the restrictions that are imposed on adults' ability to access this sexually themed material? Or instead, do we say this is a restriction on minors' ability to access the material? It's an age verification requirement. Minors have no constitutional right to access it, so we should apply something less, maybe just a rational basis level of review, because minors don't have a First Amendment right to access the material anyway. And there are precedents that point different ways on this question, but none definitively resolves it, which is why this case is here. There is a case about minors' access to pornography in the pre-internet context, a case called Ginsburg versus United States, ending ERG, Ginsberg, which involved a regular bookseller who was prosecuted for selling materials that were obscene as to minors. And the court upheld that limitation on speech while applying the very low-level rational basis review after concluding that the minors had no ability to access it, and it was perfectly okay for the government to have a kind of reduced scale of obscenity for minors. That is, material that would be non-obscene for adults could be obscene for minors, and therefore it was constitutional to prohibit minors from accessing this material. Therefore, it was constitutional to prohibit the bookseller from selling the obscene as to minors material to minors. But in a more recent case involving the Child Online Protection Act, an internet-focused statute, the Supreme Court said that limitations on access to sexually themed materials on the internet have to take account of the impact of those restrictions not only on the children who are supposed to be protected, but also on the adults whose ability to access the material will be limited. Now, the court in this case applied strict scrutiny to that question. The Fifth Circuit, in the case that's under review now, said that that the court didn't really address what level of scrutiny to apply, and maybe the issue wasn't argued, wasn't pressed that much by the government or any other party in that previous case, Ashcroft versus Free Speech Coalition. But I think the likelihood is that the Supreme Court will say that this age verification law, like the age verification requirement in Ashcroft, limits adults' ability to access material that is constitutionally protected as to them. And if, therefore, it's going to pass constitutional review, it should have to pass strict scrutiny. And the fact that this law may be trying to achieve some kind of benefit to minors may overall have the objective of keeping minors away from this material that is harmful as to them, I don't think is going to carry the day. at least if there are any other sort of ways of protecting minors that are more narrowly tailored than this one is, and there seem to be. This statute, in requiring certain kinds of age verification matters, does impose quite a restriction on adults' ability to access material. It requires them to provide these websites' ability to distribute those identification forms to anybody else. It does require the websites not to retain them, but doesn't impose any limitations on the distribution of them. And so it is entirely possible that a court applying strict scrutiny would say that this is a restriction that is too much, that is not narrowly tailored to serve a compelling interest, even if we say that keeping minors away from this sexually themed material is a compelling interest.
Thank you, Professor Domino. We're going to go now to Jennifer Dickey to hear about FDA v. R.J. Reynolds Vapor Company.
Thank you, and thanks to the Federalist Society for inviting me to participate. Of course, the usual stipulation that all commentary and errors are my own. FDA versus R.J. Reynolds is part of the now long-running dispute over e-flavored cigarettes, but it could have big implications for administrative law. So essentially, e-cigarettes were on the market, and then in 2016, the FDA deemed them covered by the Tobacco Control Act, which generally means that a manufacturer is going to have to obtain pre-approval by the FDA before sending a product onto the market. So recognizing that there's a problem, the FDA established an enforcement discretion policy allowing certain e-cigarettes to stay on the market as long as they were subject to a timely filed application for approval to go onto the market that had not yet been denied. This case arises out of the subsequent denial of approval to market R.J. Reynolds menthol Vuse e-cigarettes. The Tobacco Control Act allows any person adversely affected by such denial to petition for review in, quote, the circuit in which such person resides or has their principal place of business, end quote. So although RJR resides in the Fourth Circuit, it joined with two retailers, one based in Texas and a Mississippi-based trade association, to file a petition for review in the Fifth Circuit. The question for the Supreme Court is essentially, can they do that? But that involves two subsidiary questions. The first is whether the retailers are persons adversely affected such that they can bring a petition for review in the first place. And second, whether RJR can join them in their petition in the Fifth Circuit. Starting with the first question, it's worth noting that this case comes at a time when the court has been, I would say, more generous rather than less about allowing judicial review of agency action. And the court is going to be thinking about this in the context of a number of similarly worded statutory review provisions. So the court's going to recognize that what it says here about who qualifies as adversely affected could have implications beyond the Tobacco Control Act. Indeed, the court is even hearing a case in March about whether the Hobbs Act, which authorizes a party aggrieved by an agency's final order to petition for review, allows non-parties to obtain review. So it's not hard to imagine that they'll be drawing parallels amongst these cases and trying to figure out who's adversely affected, who's aggrieved. Here, RJR has a pretty intuitive argument that retailers who are already selling a product are going to be adversely affected when the FDA denies authorization to market that product and even threatens enforcement actions if they don't take the product off their shelves. But the Solicitor General's arguments about the statutory context are not without force, particularly in light of the Supreme Court's repeated instruction that language like aggrieved has to be understood in light of the zone of interest tests. Justice Thomas said that's like a common law background principle against which Congress is acting, that person aggrieved is in light of the zone of interest of the statute. And so here, the statute directs FDA to issue its approval or denial order to the applicant, does not give retailers a role in the agency process or any procedural protections, and is subject to confidentiality provisions that would effectively bar retailers or would-be retailers from bringing these petitions in the ordinary course. So the court will surely be pressing on these statutory indicia during the argument. If the court finds that the retailers have standing, then that will lead to the second question about whether RJR can join the retailer's petition. This venue question comes at a time when the federal government has been making more and more aggressive arguments about venue, frustrated with being forced to litigate in district courts or in circuit courts that they perceive as hostile. The federal government has been trying to get these cases transferred to DC, or at least to circuits that they perceive as more favorable. The Fifth Circuit and courts within that circuit have been generally resistant to this strategy. And I'm interested to see what the Supreme Court's reaction is. The judicial review statute here is written pretty explicitly to require a petition to be filed where a petitioner resides. But like many venue statutes, it's written only in the singular. It doesn't talk about what happens when you have joint petitions. And courts have long allowed joinder of non-properly venued claims with properly venued claims for judicial efficiency's sake. So it will be interesting to see whether the court views that practice as a background legal principle against which this venue provision should be read, or whether it agrees with the Solicitor General that the clear meaning of the text is that each petition must be filed in a venue that would be proper as to each particular plaintiff. And I should note that to that list of two questions, RJR actually wants to add a third, which is whether the court can even review the issue in this cert before judgment posture. So basically, this case, there's no final judgment yet. The court granted it after the Fifth Circuit denied a motion to transfer. And the certiorari statute says that cases in the courts of appeals may be reviewed by writ of certiorari granted before or after rendition of judgment or decree. But ordinarily, when the court grants cert before judgment, it is effectively standing in the shoes of the appellate court and exercising appellate jurisdiction. Here, RJR contends that's not true because when a court of appeals hears a petition for review, it's exercising original jurisdiction, not appellate jurisdiction. And the court lacks statutory authority to exercise original jurisdiction over this matter. RJR flagged the unusual posture of this case in its bio, but they didn't make the full-throated jurisdictional argument that they're now making. So we'll have to see at oral argument whether it gets any traction. But in sum, I think this is one of the most interesting cases in the January sitting for those who frequently sue the federal government because it has huge implications for who can sue and where they can do it.
Thank you, Jennifer. We're going to move on to our next case, McLaughlin Chiropractic Associates v. McKesson Corporation. And for that, we're going to hear from Brian Weir.
Like my colleagues, I want to thank FedSoc for inviting me to do this case. I think it's a really interesting case and touches on some of the work that I do. So this case is ostensibly about an archaic mode of communication called faxes, but what it's really about is when and where you can challenge agency actions. So the baseline rule for challenging a new regulation comes from the Administrative Procedure Act, and it says you have to file a challenge to a regulation within 6 years, and you can do it in federal district court. That's the baseline rule behind all regulatory activity. Now, Congress has passed agency-specific rules that modify that baseline rule. There's at least 35 of these. And typically those set a specific deadline for challenging an agency, a new regulation or a rule in a pre-enforcement posture. That is, a regulation gets issued by an agency, you want to challenge that thing right out of the gate. But in almost all contexts, you can wait until that regulation is actually applied to you, whether it be in an enforcement action by the agency itself or in a private litigation, to actually challenge that regulation. You can say it's an unlawful regulation. This case is about the Hobbs Act, one of those 35 statutes, and how it operates in this context. So the Hobbs Act applies generally to rules by the FCC, some SEC rules, some energy rules, and things like that. And I'm going to try and share it because this is a textual case on the screen, and I may fail horribly. I think I've shared the rule. Does everyone see it? Great. So the statute, the Hobbs Act, says the Court of Appeals has exclusive jurisdiction to enjoin, set aside, suspend, in whole or in part, or determine the validity of all final orders of the Federal Communications Commission. This case is about interpreting that statute. In this case, the factual background is that the Telephone Consumer Protection Act prohibits what are called junk faxes, which these are faxes that are advertisements that the recipient of the fax didn't actually consent to receiving. Apparently, this was a problem in the 80s and 90s when advertisers would send faxes to your fax machine and you had to print that. It would automatically print them off and use your paper and your ink. I guess it was a big issue. Today, standard fax machines aren't used typically, but faxes are still sent electronically, computer to computer. The FCC initially interpreted the TCPA to prohibit that type of fax too, even though it wasn't taking up any ink or paper. It was just being received as an email or through some other medium on your computer. Now, if you receive one of these faxes, you have a private cause of action. You can sue the person who sent the fax, and there are statutory damages of $2,500, which makes it very attractive for class action plaintiffs. The petitioner in this case, McLaughlin Chiropractic, received one of these electronic faxes from the respondent McKesson Corporation, filed a class action against McKesson, and relying on the FCC's interpretation that electronic faxes violate the TCPA, the district court certified a class against the defendant for sending these faxes. Then the FCC changed course. In an interpretive rule, the FCC decided that electronic faxes actually are not prohibited by the TCPA. And before the district court, McKesson, the plaintiff, said, this new interpretation is wrong, it's unlawful, you should ignore it, district court, and stick with your order certifying the class. The district court said that the Hobbs Act actually prohibited it from considering the validity of the underlying of the rule. It said that all challenges have to go to the Court of Appeals within 60 days under the Hobbs Act, and McKesson, the plaintiff, did not challenge the rule in that time period. In other words, the FCC rule bound the district court. It had no ability to determine whether it was valid when it was being applied to a party. So the question presented in the case is whether the Hobbs Act requires the district court to accept that interpretation, or whether a party can challenge the validity of a rule subject to the Hobbs Act when it's being applied to them after the 60-day period. This is not the first time this issue has come to the Supreme Court. In 2019, in a case called PDR Network, the exact same question presented came up. It was a defendant in that case instead of a plaintiff. And 5 justices in the majority, quote, found it difficult to answer this question and punted and remanded down to the lower courts. It didn't want to decide it. 4 justices led by Justice Kavanaugh would have held that the Hobbs Act does not bar a litigant in this posture, a private litigant, from challenging a regulation in private litigation in a very, frankly, sternly worded concurrence that probably started out as a majority and ended up as a concurrence over the course of the term. So the case is back to the court. There are 3 sort of main lines of arguments the parties have made. Again, I'll share my screen because the first is textual. I think I've done that again correctly. So McKesson, the plaintiff, says, look, no one says we're trying to enjoin, set aside, or suspend a rule, and determine the validity of is just another way of saying enjoin, set aside, or suspend. We're not trying to do any of that. This is different than sort of seeking that type of equitable relief. We just don't want it applied to us. In other words, a regulation can still be applied to anybody else in the country, but in the context of this as applied challenge, you can't apply it to us. The respondent, the defendant, says, no. This thing says exclusive jurisdiction. It's right there in the statute, and determine the validity of is exactly what the plaintiff is trying to get you to do. And if that just means the same thing as enjoin, set aside, or suspend, then that would be superfluous. It must mean something different. And therefore, the Hobbs Act prohibits you, district court, from determining the validity of this regulation. So that's the primary fight in the case. There's a couple of secondary fights. The first is the plaintiff's, the petitioner in this case, relies pretty heavily on the presumptive, what's called the presumption of reviewability. The Supreme Court has long said there's a presumption that regulations and rules should be challenged in any context. And here the text is actually silent as to whether an as-applied challenge to a rule in a private enforcement proceeding is subject to the Hobbs Act. There are a couple of other statutes under the Clean Air Act, CERCLA, and the Clean Water Act that specifically bar a party from challenging a regulation in a private enforcement context like this, which is what the defendant wants in this case. There's a case from the 1940s called Yakis, where there was a statute under the Price Control Act during the Second World War that did the same thing. And the plaintiffs in this case say, look, Congress knows how to cut off all review in private litigation, and it hasn't done so here. The third sort of argument that the plaintiffs make is if we're subject to this challenge and we can't subject to this regulation and we can't challenge its validity, there's some due process concerns there. And also there's some Article 3 concerns there, because basically you are delegating to the FCC the exclusive authority to interpret the statute and taking it away from district courts. And of course, courts are what are supposed to be the branch that interprets the law. The respondents' counter arguments, the defendants' counter arguments there are, look, you had the ability to challenge this within the 60-day window. You didn't do so. That's on you. I think the impact here, if the court rules that Hobbs Act actually forecloses review of regulations after 60 days, any sort of review, even as applied review, I think for the agencies subject to the Hobbs Act, that will create some perverse incentives. Agencies can issue binding rules via using interpretive rules, which is what this case is about, which are very easy for agencies to do. I think for parties, it will create some serious problems as well. There's no way for regulated parties to know of all rules that are being challenged that could affect them, way down the line, much less be able to challenge them within 60 days of them being issued. And for the entities out there that are looking at the Federal Register for these problems, it also creates perverse incentives for them. They have to challenge it within 60 days, or they lose their ability to do it, even if they're not sure the rule is going to apply to them in the future. I do think sort of my prediction here is the court took the case again for a reason. I think the court probably ultimately, there were 4 justices that said you can challenge regulations in this as applied context under the Hobbs Act. They just need one more. And I think, I do think they're going to try and resolve this. And my guess is they're going to say you can challenge it. And just one final point, the respondent seems to see that writing on the wall. It asks for an alternative ground of affirmance on the merits of the FCC's interpretation, which has not been litigated on before the district court or the Court of Appeals, which I'm not sure I've ever actually seen that in a Supreme Court brief. And they also asked the court to dismiss it as improvidently granted based on some threshold issues that they did not raise in their bio. So I do think that the outcome here is going to be ultimately that you can challenge the regulation.
Thanks, Brian. We have a few more cases here. And so just a reminder, if you have some questions for us, you can submit them via the Q&A feature or in the chat, and we will try to get to those at the end of it. We're going to now turn to the case Barnes v. Felix. And for that, we're going to go back to Vikrant Reddy.
Thanks again, Brett. Thanks again to the Federalist Society for giving me the opportunity to do this. When I talked about Hewitt, I was pretty confident about how I thought the case was going to turn out. I will make no such representations about Barnes versus Felix. I think this is a much harder case. It's very challenging, and we should talk through it. It's a case about a doctrine that the Fifth Circuit has come up with called the moment of threat doctrine. What's the moment of threat doctrine? Well, whenever law enforcement uses deadly force and is alleged to have used excessive force, courts have got to look at the reasonableness of what the police officer did. Now, when you start thinking about reasonableness, you ask yourself, or courts need to be asking themselves, what's the time period they're looking at? Are they looking at the exact moment that the police officer decided to make the decision they did to fire their weapon, or what have you? Or are they looking at the whole period of time leading up to that? And you might be thinking, that seems like a weird kind of technical artificial distinction. Does this really make a difference? It does make a difference. And I'll tell you why it makes a difference. Because if you're thinking about that whole period that leads up to the instant in which the force is used, you might start asking yourself questions about what exactly the police officer did during that time. Did the police officer himself or herself make decisions that actually escalated the intensity of that situation? Did they make decisions that made the entire interaction needlessly dangerous? And then did they use deadly force and justify it by saying, gosh, things were spiraling out of control. I did what I had to do. It seems a bit rich to make that argument if you yourself were contributing to the situation. However, there's a counter argument, which we'll get into. But that's really that's kind of the crux of the case here, is whether or not you're looking at this moment or you're looking at the time leading up to the moment. And frequently the reason it's become such a big debate is that we're thinking a lot about the police officer's actions. There's a big circuit split on this. There are 4 circuits, including the 5th, that say you look at that moment of threat. There are 8 circuits that say, no, you look at the time leading up to the moment of threat, including that moment, whenever you're trying to analyze the situation. When you've got a circuit split like that on a serious public issue like this, you're going to get Supreme Court review. That's what we have. That's what we've got here. Talking for a minute about these situations in which you look at what the police officer did leading up to the moment that force was used. I think there's a really interesting story that comes out of one of the amicus briefs. I'm going to tell this one before I get into the details of this case. This was filed by the Cato Institute, and they tell the story of a man named Andrew Scott. Andrew Scott has police officers come to his door incorrectly. They have the wrong address. They're knocking on his door. They don't identify themselves as police officers. They don't have the lights going on their car. He doesn't really know what's going on. He approaches the door with his firearm pointed downward. He opens the door. Things get a little bit scary on both sides. He can kind of see that there are people at his door holding guns. The police officers can see that somebody has just opened the door who's holding a gun. The police officer, one of the police officers makes the decision to kind of run in to the room while Andrew Scott is actually retreating, and he fires his gun at Scott. Injures him. He may have killed him. I don't recall the exact details from Cato's amicus brief. But this is a situation where, you know, you're looking at what the police officers did. They made a lot of mistakes in terms of just kind of basic policing whenever they approached Andrew Scott's door. That's worth thinking about. On the other hand, it's also worth thinking about the fact that, you know, the fact that you as a police officer have made some mistakes doesn't mean that you've negated your right to self-defense. It gets to be a complicated issue, and it gets to be unbelievably fact-specific. Let's talk about the facts in this case, the Barnes case, and you get a sense of just how incredibly detailed these stories can be and how you have to look at every single thing that happened. This case comes out of Houston, Texas. Our last one came out of Dallas, Texas. Here, Mr. Barnes is driving down the Sam Houston Tollway in Houston, for those who know it, and he's off to go pick up his girlfriend's daughter from daycare. Officer Felix gets a call alerting him that this car, which is a rented car, by the way, is attached to some unpaid tolls. So he pulls the car over. So Barnes pulls over into the left median. Officer Felix is behind him. Felix gets out of the car and he's walking up to the driver's side. He says, you know, roll down the window. He asks for ID. Barnes starts fumbling around. He can't find his driver's license. He says, you know, can I look in the glove compartment? He says, could I look down here underneath the passenger seat? He's looking all over the car. He can't seem to find the license. And Officer Felix is just kind of watching him look nervous and not be able to find a driver's license. And he says to him, you know, I think I smell marijuana. Is there anything I need to know? And, you know, Barnes is kind of nervous about what's happening. And he says, listen, I think that the driver's license may be in the trunk of the car. Could I go into the trunk and look? Felix says, yes. So he opens the car door. And when he opens the car door, the car actually begins to start moving forward. It looks like Barnes is trying to get away. So Officer Felix has got his hand on his holster and he jumps onto the sill of the car as it's starting to drive away. He's saying, you've got to stop the car. You've got to stop this car. Car's not stopping. Felix pulls out his gun and he fires at Barnes, the driver. Car does stop, and Barnes is held at gunpoint by the police officer for 2 minutes until backup arrives. But in those 2 minutes, Mr. Barnes dies. It's a horrible, horrible tragedy. And what the courts have got to figure out is whether or not the force that was used by Officer Felix was excessive deadly force. The case went up to the Fifth Circuit, and they applied the moment of threat doctrine. And they analyzed the case to say that, you know, the officer is in a situation where the car seems like it's about to drive off. It could have been a danger to others who are on the road. Officer Felix pulled out his gun, he fired it. We're applying the moment of threat doctrine and saying, if you apply that doctrine, this is how the case would go. However, I think this is really fascinating. The judge who wrote the opinion, Patrick Higginbotham, terrific judge. I took federal courts from him in law school, as a matter of fact. Hello to Judge Higginbotham. Judge Higginbotham concurs in his own opinion and says, listen, I'm applying this doctrine because it is the Fifth Circuit doctrine, but I think it's wrong. I think you do have to look at the totality of circumstances that are much broader in the way that 8 other circuits do. And I think that if you do that, you have to say to yourself, look, what's basically happened here is that you have a case of unpaid toll tickets and somebody trying to get away, not somebody trying to get away from murder or sexual assault or something like that. The idea that the police officer would jump on the sill and pull out his gun and fire is reckless. And I think it is excessive, an excessive use of deadly force. And I would encourage the Supreme Court to review our moment of threat doctrine. There are a gazillion amicus briefs filed in this case. Actually, instead of saying a gazillion, I think I have the exact number. There are 15 amicus briefs filed in support of Mr. Barnes' position. There are 9 amicus briefs filed in support of Officer Felix's position. The main briefs in the case are incredibly interesting. They're very well written. They're very well done, as you would expect they would be. They're written by some of the best Supreme Court practitioners in the country. Neil Katchel has written the brief in support of Mr. Barnes, and he asks what I think is kind of a sort of a snarky but also clever and entirely relevant question. He says, look, the Fifth Circuit is saying that we should examine just these 2 seconds in which Officer Felix made his decision. Are we not allowed to expand that to 3 seconds? That's what the case is about. It's an interesting way of thinking about it. On the other hand, Officer Felix's brief is written by Lisa Blatt, again, one of the finest Supreme Court practitioners in the country. And she makes the point that I made just a moment ago. Yes, police officers make mistakes, but in the moment that you make, just the fact that you've made a mistake does not suddenly abrogate your right to defend yourself whenever things begin to spiral out of control, or, by the way, to defend others around you if you think that what you're doing is in the best interests of the public. It's challenging. I don't have a good sense of what's going to happen here. If I had to bet, I would bet that Justice Alito would find in favor of Officer Felix. Justice Sotomayor would probably find in favor of Mr. Barnes. Beyond that, I don't know. I really don't know how the other 7 justices will analyze this. There's a very colorful line from Justice Scalia in some old case where he says that in these kinds of excessive force cases, you have to slosh your way through the fact-bound morass of reasonableness. I love that line. It's very colorful. It makes me miss Justice Scalia, as I do all the time, and the terrific writing that he produced in our law. But it also gets at a reality here, which is that the cases are just so incredibly detailed, hard to figure out. On a final note, before I turn it over to our last speaker, I'll just say that there are all these amicus briefs. There is one in particular that I really like. It came from the policing project at New York University's law school, and was submitted by a whole bunch of people who are in law enforcement. I'm on the advisory board of this policing project, so I'm a little biased here, but take that as you will. I will say that the thing I loved about this brief is that it tried to really take down the temperature on these policing conversations by saying, it feels like this case is being analyzed as a red team, blue team, pro-cop, anti-cop kind of case. It doesn't need to be that way. When you are looking at the totality of the circumstances and reviewing all the decisions that the officer made leading up to the use of the moment of force, there can be a lot of exonerating information there too. You could often find that police officers were doing things by the book and making all the right decisions. And it becomes very exonerating for them that they happen to use deadly force when they perceived a threat. This is not something that should necessarily be viewed as team cop, team anti-cop. I think that's a smart way of thinking about it, and that's the way that I suspect and hope the court will look at it too.
Thanks, Vikrant. We're going to hear from our last speaker now, Greg Porter, who is going to tell us about Cunningham v. Cornell University.
Thank you, Brett. Thanks for the Federalist Society for hosting this panel. This case is another statutory case. It's about the pleading standard when a retirement plan participant alleges that the plan fiduciaries entered into a contract for retirement plan services that resulted in excessive fees that decreased retirement savings. Now that sounds pretty dry, but let me give you some sort of background numbers that I think will help out all the listeners appreciate the significance of this case. And the first one is that there's about $12.5 trillion invested in defined contribution plans in the United States. Defined contribution plans are 401k plans and plans provided by not-for-profit private institutions like Cornell and hospitals and the like. About 3/4 of that $12.5 million is in 401k plans, and 401k plans are by far the primary retirement plan offered to private sector employees. So there's a lot of money in this system, and as Willie Sutton once said, you know, why do you rob banks? Because that's where the money is. And 12.5 trillion is a lot of money. And so why does this matter to employees and retirees in America? Because most of their money is in 401k plans, their retirement savings depends on investment returns. And by far, the data shows that the main driver of investment returns are fees associated with investments, whether they be record-keeping fees or investment management fees. So as a general rule, the more fees you pay, the lower your investment returns and the lower your retirement savings upon retirement. So that's why this case matters, and it's above and beyond the dry pleading standards under the Employee Retirement Income and Security Act. So let's talk about a little bit about the Second Circuit case that's on appeal here. In that case, the Second Circuit held that a plaintiff and participant alleging that the retirement plan fiduciaries entered into an unreasonable contract with a service provider must plead more than just that the occurrence of the transaction. The way the statute is constructed is it has a set of prohibited transaction rules, which are described as per se violations. And in this particular transaction, the per se violation is the fiduciaries for the plan cause the plan to contract with a party in interest, i.e. the service provider. As a general rule, when a plaintiff alleges a violation of the prohibited transaction rules, the burden then shifts to the fiduciaries to prove one of the statutory exemptions under section 1108 of the statute applies. Now, the Second Circuit said, at least as to this particular kind of prohibited transaction, the one in which you've got arrangements between a service provider and plan, we're not going to do that burden shifting at the pleading stage, and the plaintiffs are going to have to plead more than just the bare elements of the prohibited transaction. They're going to have to prove that the arrangement was some for services that were unnecessary, or that the compensation was unreasonable. And as to the unreasonableness of the compensation provided to the service provider, we're going to adopt the standards set forth for pleading unreasonable compensation in mutual fund context under Rule 36B, where the courts have held that the compensation is essentially so unreasonable in relation to the services provided that it doesn't like pass a kind of rational basis test. So the Second Circuit is not the only circuit to have held that for this particular kind of prohibited transaction, you have to plead more than the bare elements. Three other circuits have held the same way, and two have held no, it's enough to plead the bare elements. So that's why I think the court accepted the case, because you have a circuit split. Not only do you have a circuit split on that, but you also, the courts that have adopted the rule that you have to plead more than the bare elements have different rules or tests about what that more is. And so that's the court is the Supreme Court's going to have a sort of a menu of choices of how to deal with this case. One, it could resolve the circuit split by simply saying on the plain text analysis, which is favored by many conservatives on the court, which is say the statute says what the statute says, and you plead the elements, and that's that. And so we believe we're going to go with the two circuits that have gone that way, and that's one option. The second option will be the court will sort of carve out this particular kind of prohibited transaction for the same reason that circuit courts have done so, i.e. that these are such common transactions in the marketplace that it would make virtually every arrangement a prohibited transaction, and we can't have that, various policy grounds, lead to a proliferation of litigation, burden plans, and service providers on reasonable costs, et cetera, et cetera. I'm sure you're all familiar with those kinds of arguments. They arise in multiple contexts. And then it'll have to decide what the test to adopt in terms of the additional pleading requirements. My firm filed an amicus brief on this case, specifically on the issue of the Second Circuit's adoption of the Rule 36B test or additional pleading requirement. We took the position that we didn't take a position on whether additional pleading requirements should be demanded of plaintiffs, but what we did say is that if you do require something, it shouldn't be the 36B test, because it's a completely different context. And the reason for that is that the 36B test is essentially founded on the presumption that mutual fund investors operate in an open marketplace and are free to vote with their feet, right? If you don't like the mutual fund fees, divest and go buy a different mutual fund, go buy an index fund from Vanguard or something like that if you don't like the high fees associated with the mutual fund. It's sort of caveat emptor. You bought the fund, you invested the fund. Who are you to complain about the fees after the fact? So that's why the bar is set so high. But ERISA is an entirely different context. The retirement plan participants can't vote with their feet. They're, if you will, captive investors. They are subject to the decisions of the retirement plan fiduciaries. The retirement plan fiduciaries pick the service providers. The retirement plan fiduciaries pick the investment offerings that are in the plan. The retirement plan participants have no say in that and cannot control it. And therefore, to impose upon them a market-based test, the notion that they're operating in a free marketplace, doesn't make sense. I think the way the court could go, which would be going way beyond the scope of the question presented, would be that it could decide that the statutory exemptions to the prohibited transaction rules are not affirmative defenses. This would go against basically all the circuits that have ruled on that issue. It would also, again, go against, the common law of trust from which ERISA is derived and which the court looks to on a regular basis to inform its analysis. It would also go against, common statutory analysis principles that this court has adopted in the past, the Supreme Court has adopted in the past, which essentially anytime you have something called an exception or exemption under the statute, it has always been treated as an affirmative defense. And there are several Supreme Court decisions that go that way. So that would be the sort of outside the question and presented and much further outside the scope of the narrow issue presented to the court. But you know, this court has never been known to limit itself to the question presented. So it's quite possible that it could go much further than what the parties have brought before it. So if I had to guess, I would guess they would try to, they would set the proposition that this particular kind of prohibited transaction is different than the others, and plaintiffs have to plead more. What that more is might be some level of unreasonableness of compensation, whether they go as far as to adopt the 30B6 standard. I hesitate to say. I would doubt it because I think they recognize it's a different context. But there is a ton of circuit law, and the court has reviewed this before in a case called Hughes about pleading excessive fees in retirement plans. I think so the court has ample material to work with to craft a standard that won't go so far as 36B, but also won't be too disruptive of the existing legal landscape. Thank you.
Thanks, Greg. There's one more case on the docket this month that I will briefly mention. That case is Stanley v. City of Sanford, Florida. In this case, the court's going to decide whether under the Americans with Disabilities Act, a former employee loses her right to sue over discrimination with respect to the benefits that she earned while employed because she no longer holds her job. This is a case that involves a retired firefighter with Parkinson's disease, and she alleges that her former employee discriminated against her when it discontinued part of her health insurance benefits 2 years after she retired. The 11th Circuit held that the ADA requires a plaintiff to hold or desire a job, which in order to bring a claim, which a retiree does not, and ruled against her. This looks to be, I think, another case for the court's textualist wing to kind of flex its muscles. And so we'll see how that one gets decided. I think we might have time for one question. So I'm going to pose this to Professor Domino if he doesn't mind. And that question, I'll summarize it in this way. Why is there a right to access pornography, particularly in light of the Supreme Court's decision in Doe v. Reed, which rejected a challenge to a disclosure rule related to signing a petition?
I think the question of whether there's a right to access pornography without providing an ID has to be made by reference to the general principle that pornography is protected speech unless it's obscenity. So the right to access pornography anonymously is the same question as the right to access any protected speech anonymously, any aspect of literature, any kind of political speech, any kind of protected speech at all. And there, if you impose a requirement that people who access speech have to do so disclosing their name and making their names and whatever they're trying to access public or at least available to some people, that's going to be an impediment to exercising those free speech rights. If you want to access material, you want to have a conversation, you want to go on the internet and look up any kind of protected information, you want to go and figure out what the Republican or Democratic Party platform is, if you had to put your name in some database as saying, I, Michael Domino, on this day decided that I was going to read the X party platform, that would be an impediment. I might think twice about accessing that information, engaging in that First Amendment conduct if I had to take that cost of making myself public when I did it. And so the reason, in essence, is that forcing people to go public when they access protected information is a penalty of sorts on accessing that First Amendment protected material.
Thank you, Professor Domino. And it looks like we have hit the 90 minutes in 90 minutes or less. So I'm going to turn this back to Nate. Nate, I think that you're muted.
My apologies. I was going to say I was a little doubtful, but we were in fact able to squeeze in this big panel, and it was a great preview. Many thanks to all of you. For our audience, your feedback would be appreciated at info@fedsoc.org. I did also want to say that in 2025, the practice groups have many webinars, luncheons, and upcoming conferences planned, and we look forward to seeing you at them soon. Until then, we are adjourned.